everybody. Last part of the chapter. Now, this part deals with legality aspects. I want to throw that out there. So, if you don't get to this in class, this is something you should review because ultimately this will affect you and others. So, and these aspects could possibly be on the final exam. So, let's talk about this. All right, some basic labor relations statistics and information. In 1974, the Privacy Act was created to give employees legal rights to examine letters of reference concerning them. So if someone sends a letter of reference for you, you have every right to look at it. In 1986, the Immigration Reform and Contract Act shows that it requires employers to verify the eligibility for employment of all their new hires. So including US citizens, you all have to fill out what is called a W4 to make sure that you had eligibility to work. Oh my goodness, in the United States. And then in 2003, we already went over this when we went through I think every one of the classes so far. The Sarbanes-Oxley Act, which prohibits employers from demoting or firing employees who raise accusations of fraud and take that information to a federal agency, because the accountant at Anderson at Enron, she actually took what was going on within the company to the FBI. So, a couple of different basic aspects you should know. We have the NLRB, or the National Labor Relations Board, which enforces procedures whereby employees may vote to have a union and collective bargaining. And then we have collective bargaining. And for this aspect, it consists of negotiations between management and employees about disputes over compensation, benefits, working conditions, and job security. So, some of the other laws um, that I haven't gone over, and there's a lot of them. That's why I said this is just a basic review for you guys. First is the Employment Retirement Income Act, Security Act, which sets rules for managing pension plans, providing federal insurance to cover those bankrupt plans. Because unfortunately, sometimes when companies go out of business, um, if it's a federal plan, it's backed up so people don't lose their retirement, because the company, that money that they're saving for you is probably part of that bankruptcy. In 93, the Family and Medical Leave Act came about. I can't believe it did not go into effect until 1993, but it requires employers to provide a 12 weeks, up to 12 weeks of unpaid leave for family medical, um, including childbirth, adoption, family emergencies, things of that nature. HIPAA just came into place in 1996, which is the Health Insurance Portability and Accountability Act. It allows employees to switch health insurance plans when changing jobs and receive new coverage regardless of any pre existing health conditions. This includes group plans. And a lot of people, I'll be honest with you, used to drop people because of them being sick. I actually ran into this situation when I was 21. I had a thyroidectomy. So basically, what that means is they go in and they remove either all or part of your thyroid due to thyroid cancer issues and what is called a goiter, which is a big lump in your throat. When they removed that, I officially had thyroid disorder for the rest of my life. I have to take medication every day still. And the first part of that, I was denied because it was a pre-existing condition, and insurances would make you wait 3 6 months before they cover you. Well, someone who has a pre-existing condition, they can't just stop taking medication. Well, they can, but it's not healthy. So this is a good thing. HIPAA also protects you as an employee, that your employer does not tell others your medical aspects. Same at the doctor's office. Then we had the 2007 Fair Minimum Wage Act, which increased federal minimum wage to 7.25 for an hour. Now, when I was in high school, the minimum wage was 5.25. So I'll be honest with you, 725 does not seem like very much with how much it costs to run a household today. Others is the Social Security Act of 1935, which is established by the U.S. retirement system. There's the Fair Labor Act of 1938, or FLSA, which established minimum living standards for workers engaged in any type of interstate commerce, including provision for a specific federal minimum wage and a maximum work week before overtime must be paid, along with banning child labor. So, labor unions had a big effect on some of those laws that came into place as well, including this one. Other health and safety laws, we've got OSHA, which is the Occupational Safety and Health Act, and it actually establishes minimum health and safety standards depending on the company that you work for. Like, for instance, in some companies, like if you work in food service, you need to wear a hairnet in some cases. You also need to have gloves when preparing food. Washing hands. Your chemicals need to have what's called MSDS sheets, etc. And multiple occupations may have different types of OSHA requirements. Then we have COBRA, and basically in 1885 that came about, which is the Consolidation Omnibus Budget Reconciliation Act. And I had no idea that that was what the acronym was called. I just knew it as COBRA. And basically, what happens is when your job is terminated, a company is required to give you the opportunities to keep your insurance, which is called COBRA. And it costs a lot more money to keep that insurance, but they are required to let you have the opportunity for that. And then 2010, we have the Patient Protection and Affordable Care Act, and that's where employers with more than 50 employees must provide health insurance. Before 2010, if you were an employer with less than 50, you did not have to provide health insurance, even if the employee was working full time. All right, so we already went over those. Oh, couple more, and there's a lot. That's why I said this is a like extra video. So, equal employment opportunity is very important. 1963, they enacted the Equal Pay Act, which requires men and women to get paid equally for performing equal work. In 1964, they amended the the Civil Rights Act also in 1972, or Title 9, and that's prohibiting discrimination on the basis of race, color, religion, national origin, sex, or sexual orientation, and it all depends on um, where you work, because some companies have an even more extensive um, provision for this. This is just the required federal provision. Then there's the ADEA, and this has become a much bigger aspect in the United States. So it was enacted in 1967, but then amended in 1978, and then again in 1986. And this prohibits discrimination in employees who are over 40 years old. It also restricts mandatory retirement, because 40, 50 years ago, they could say you absolutely have to retire right when you turn 65, or after 20 years of service, or after 30 years of service. And then the Civil Rights Act, which is the amends and clarifies the Title 9 ADA and other laws. It permits suits against employers for punitive damages in cases of intentional discrimination. All right. Then in 19 well, after in 1964, they actually created the EEOC, which is the Equal Employment Opportunity Commission, and their job was to enforce anti-discrimination and other employment-related laws, so people were not being discriminated against. It applies to all companies and their agents engaged in the industry, affecting any type of interstate commerce, and employs more than 15 people. So if you run into issues like workplace violence or workplace discrimination, and discrimination itself can have a really adverse impact on someone. And many people be honest, you don't want to be there. So absenteeism increases, morale within the company decreases, especially for this particular employee. There's a lot of things that happen to this employee, and some are going to fight because they feel like discrimination is should not be occurring, and some people are just going to give up. So, but it has a direct negative effect because if your company is known for discriminating against people, people are going to hear about it. People are going to hear about it. All right, now let's talk about disparate treatment. So, disparate treatment as a whole, it results when employees from protected groups, such as individuals who are disabled, are intentionally treated differently. The only thing someone who is different or has any type of intellectual, physical, mental disability is they may need an accommodation here or two. You know, if you are in a wheelchair, you need to be able to get into the room with your wheelchair. You need to be able to get under your table or have access to get into a chair. You know, things of that nature. These are basic components that should be provided by the employee anyway. So, an example of this aspect is would be making a decision to give all international assignments to people without disabilities because of the assumption that they won't need any special accommodations related to travel. Assumption based on someone who has a disability. Next is affirmative action, which focuses on achieving equality and opportunity within a company. It's been around for a long time. Some people are questioning this aspect because they're predicting in the next 20, probably 25 years, the white male or white Caucasian male, well, Caucasian's the same thing, will actually be a minority in the United States. And this particular action was created to help individuals who are in the minority. That includes women as well. So people are recruit, and reduce eliminated prejudice questions in interviews and other aspects. And companies are still working on different parts of this. Next is sexual harassment, um, which should never be happening in any company, period. But unfortunately, it does. Quid pro quo harassment. So, sexual harassment consists of any unwanted sexual attention that creates an adverse work environment. That's anything from you feeling uncomfortable to, turning the person in because uh, of what they say or what they do. So this actually includes obscene gestures, sex stereotype jokes, sexually oriented posters, graffiti, suggested remarks, unwanted dating pressure, physical non-sexual contact, unwanted touching, sexual propositions, threatening punishment unless sexual favors are given, obscene phone calls, and similar verbal or physical actions of a sexual nature. So the harassment can be a member of the same sex or a member of the opposite sex, either one. And so if the harasser is a manager or even an agent of the organization, the company itself can be sued, even if they don't have any knowledge about it. So keep that um, in your mind. And then we got quid pro quo harassment, which is the type of unwanted sexual attention when they're told implicitly and explicitly, or they must um, do something, whatever it may be, or um, they will have. Basically, what this does is in some way makes it so you don't get hired or you keep your job based on quid pro quo harassment. So, hostile environment is where a person is being sexually harassed, but they don't risk any kind of economic harm, but they perceive it as in what they're doing as intimidating or offensive. So, and then last but not least, we have bullying, and bullying deals with, as you probably already know, repeated mistreatment of one or more people. This can be physically, mentally, verbal, nonverbal. This is threatening, humiliating, or intimidating. And I want to make sure I had those specific aspects. So, research suggests that the following about workplace bullying: between 30 to 55% of workers around the world have experienced this on the job, or you've witnessed this on the job. Common forms of workplace bullying include spreading rumors, yelling at people, withholding information, humiliating workers in front of other people, and even throwing things. So, bullying can occur from colleagues, managers, other employees, supervisors, but people have reported at least 50% of the places within the companies in the survey had some sort of bully. So this could even be forcing you to work long hours and yelling and behaving in intimidating and threatening ways. But directly affects your mental health, your physical health, um, and your work related outcomes. So, just to mention that, I'm not going to go through these aspects, but the labor management issues are important. Review those on your own. I'm not planning on having any of these in the quiz except for one aspect that might be there. One thing I do want to mention. So, um, a right to work law in the United States is important. So in this part it talks about union security, types of workplaces, etc. So I want to kind of go over the right to work laws and then we'll be done. So the right to work laws in individual states, it was this was actually enacted in 1947 under the Taft-Hartley Act. It passes legislation outlawing union and agency shops. As a result, at least 27 states have passed right to work laws, the statutes that prohibits employees from being required to join a union as a condition of employment, which um, they used to say, hey, if you're going to get hired here, you have to join our union. You don't have to do that. In Iowa, as you can see, we are a right to work state. So you can get hired and not be in the union. You can make that decision on your own if there is a union within the company. So just wanted to mention that. Also, it talks about other important aspects. So that is the chapter. I want to kind of do a brief over